Negotiable Instruments Act, Section 141, Offences by Companies. Section 141 of the Negotiable Instruments Act, 1881 provides that where an offence under Section 138 is committed by a company, both the company and the persons responsible for managing and conducting its business may be prosecuted. The provision incorporates the principle of vicarious liability and ensures that those controlling the affairs of the company cannot escape responsibility for cheque dishonour committed in the course of business. 1. Purpose of Section 141. The main object of Section 141 is to ensure accountability in corporate cheque transactions and prevent misuse of the company structure. The provision protects payees and creditors, promotes financial discipline in companies, and strengthens confidence in cheque-based transactions. 2. Liability of company and responsible persons. Where a company commits an offence under Section 138, the company itself is deemed guilty and may be prosecuted for the cheque dishonour. Every person who was in charge of and responsible for the conduct of the company's business at the relevant time may also be prosecuted, extending liability to responsible officers. 3. Meaning of persons in charge. The section applies to persons who were actively responsible for the day-to-day management and conduct of the company's business, such as managing directors, whole-time directors, and controlling officers. However, mere designation as a director is not sufficient to attract liability unless responsibility for the conduct of the company's business is established. 4. Defense available to officers. The first proviso protects persons who can prove that the offense was committed without their knowledge or that they had no involvement in its commission. It also protects those who exercised all due diligence to prevent the offense, ensuring that innocent officers are not held automatically liable. 5. Exemption for government-nominated directors. A director nominated by the central government, a state government, or a government-owned financial corporation is protected from prosecution under this chapter. This exemption recognizes that such nominated directors may not be responsible for or control the day-to-day affairs and management of the company. 6. Liability for consent, connivance or neglect. Subsection 2 provides that where an offence is committed with the consent, connivance, or neglect of any director, manager, secretary, or other officer, such person shall also be deemed guilty. Accordingly, officers who are involved in, contribute to, or are responsible for the misconduct may be prosecuted separately for the offence. 7. Meaning of company and director. The explanation clarifies that the term company includes a body corporate, firm, or association of individuals for the purposes of this section. It further provides that, in relation to a firm, the term director means a partner, thereby extending the section to partnership firms and similar business entities. 8. Commercial importance. Section 141 is important because it ensures corporate accountability, prevents avoidance of liability through the company structure, and protects cheque-based commercial transactions. The provision encourages responsible financial management and strengthens the effectiveness of cheque dishonour law in business and corporate dealings. For more details, contact us.